G'day, it's fugitive Australian journalist Shane Delling from the website and YouTube channel Kangaroo Court of Australia. Now, I've just published an article, and in that article, I've embedded a video. It's a recording from the Walter Sofronoff police corruption inquiry last year. And you're going to be able to watch AFP Commander Michael Chew be cross-examined in relation to lies he's telling in the witness stand under oath. And three of the key issues are that he raises the fact that the AFP at one point were considering applying for a suppression order to protect Bruce Lehrmann, obviously to suppress his name and maybe suppress other details of the rape charge he faced. That by itself raises a lot of questions. Why were the AFP considering applying to get a suppression order when it wasn't up to them? Bruce Lehrmann had his own barrister, his own lawyers, and there was a Crown prosecutor, or not a Crown prosecutor, but the Director of Public Prosecutions. He could have applied for it, or the court could have issued one by themselves if they thought Bruce Lehrmann wasn't going to get a fair trial. So the AFP, why were they considering a suppression order? Obviously, I suspect it was the politicians above who wanted it suppressed as much as possible because it was bad politically. Also, why didn't Michael Chew tell any of the investigating officers? None of them seemed to know about it. They didn't put it in their evidence. So that means it was Michael Chew and the commanders above him, which is Commissioner Reece Kershaw of the AFP, were considering the suppression order. That ties in the political cover-up, the AFP cover-up of trying to protect Bruce Lehrmann. But also Commander Chew tries to use that, the application for a suppression order, to justify the leaking or the deliberate handover of material, sensitive material, to Bruce Lehrmann and his barristers. And some of that material was counselling notes, Brittany Higgins' counselling notes, which was highly illegal for the AFP to hand over to Bruce Lehrmann's barristers. And they also handed over other material. So they were trying to give Bruce Lehrmann's lawyers and barristers as much opportunity as possible to have the case thrown out. And the AFP shouldn't have been serving that evidence anyhow. It was up to the Director of Public Prosecutions to serve the evidence. And Michael Chew tried to use that as an excuse, them potentially applying for a suppression order to justify illegally handing over that material. Anyhow, I'll read out the introduction to the article, and then I'll show you the video of Michael Chew being cross-examined. The first 12, 13 minutes, he's getting cross-examined by a counsel assisting the inquiry. Then he's cross-examined the last sort of 4 or 5 minutes by Shane Drumgold's barrister. Shane Drumgold's a former ACT Director of Public Prosecutions. He had a barrister representing him, and he did a very good job towards the end there to cross-examine Commander Michael Chew. Now, the article I published on the 21st of July 2024 is titled "Senior AFP Secretly Considered a Suppression Order to Protect Bruce Lehrmann. Smoking gun evidence of a political cover-up?" And it starts off, "Senior Australian Federal Police, with almost certain involvement from politicians, secretly considered applying for a suppression order to protect Bruce Lehrmann, but they didn't tell Bruce or his barrister. So who was the suppression order going to protect? In fact, Deputy Chief Police Officer Michael Chew says in the below video that the AFP considered applying for a suppression order not only did not consult Bruce Lehrmann or his then barrister John Corn about a possible suppression order, but Chew also did not consult any of the investigating police officers. That would mean that Deputy Chief Police Officer Michael Chew only consulted officers above him, which would be Commissioner Reece Kershaw and likely the politicians and public servants above Kershaw, such as the Prime Minister's office, and the then Minister for Home Affairs, Peter Dutton, who was replaced by Karen Andrews, and secretly replaced by Scott Morrison, who was also secretly the Minister for Home Affairs. The below video is Deputy Chief Police Officer Michael Chew giving evidence at the Board of Inquiry into the criminal justice system, or as I call it, the Walter Sofronoff Police Corruption Inquiry, on Friday the 26th of May 2023. Michael Chew seems to have a new role now as Deputy Chief Police Officer Response. The first part of the video sets a background with counsel assisting Aaron Longbottom, KC, questioning Michael Chew, and the second part is where Michael Chew is cross-examined by Shane Drumgold's barrister, Mark Tedeschi, KC, is where most of the Michael Chew's lies are exposed and where the secret suppression order is discussed. A couple of key points worth noting before watching the video. Number one, the police interviewed Brittany Higgins twice about the rape when it was only meant to be once for rape victims. Brittany Higgins said she felt intimidated. Number two, Detective Inspector Marcus Borman tampered with a police document to try and make sure Bruce Lehrmann wasn't charged. Number three, Bruce Lehrmann's barristers, Steve Whybrow and John Corn, gave evidence that Detective Superintendent Scott Muller tried to help them after Lehrmann was charged, which Scott Moller denied. Number 4, one of the 2 AFP officers that interviewed Brittany Higgins, Senior Constable Trent Matters, was recently charged with perjury, perverting the course of justice, and concealing evidence in an unrelated matter, but which occurred around the same time that Bruce Lehrmann raped Brittany Higgins at Parliament House. Now, I've got links to all those 4 issues with further details, so you can click on those links and read the further information. Now, some key points to watch for in the video. The video starts off with counsel assisting Aaron Longbottom KC questioning Michael Chew about how and why the brief of evidence and summons were served together and directly on defence. Bruce Lehrmann's barrister and police failed to follow the police's checking process, and in a situation where the Director of Public Prosecutions is meant to serve the brief of evidence on the defence, the police sent Brittany Higgins' personal counselling notes in breach of the law to Bruce Lehrmann's lawyers. Decision made by Michael Chew shows it was being managed at the highest levels. Brief of evidence and summons served at the same time, which is unusual. Michael Chew tried to blame COVID, but could not explain why, except to say courts were operating on restricted times. The process that should have been followed shows that the DPP, Director of Public Prosecutions, were the ones which should have been running the prosecution, and they were the ones to decide if there was a need for a suppression order. So why were the AFP sticking their noses in regarding a possible suppression order? I suspect former Prime Minister Scott Morrison's Department Secretary, Phil Gaetjens, would know. At the 14-minute and 30-second mark of the video, Mark Tedeschi, KC, cross-examines Michael Chew, and Chew says the AFP served the brief and summons together to start the progression of the matter to expedite it before the court at the first mentioned date. That would then allow us to seek a suppression order to limit, if not reduce, external commentary that was occurring, Michael Chew said. All high-profile court cases have media reporting, so who wanted to stop the external commentary and who would have benefited? Mark Tedeschi, KC, points out the AFP could have gotten a suppression order with just a summons being served. There was no need to serve a brief of evidence. Michael Chew agrees, and he would have already known that, so his lies are exposed. Michael Chew says it's the only case he knows of where counselling notes were being served and recording of Brittany Higgins' interview, which was the evidence in chief interview, being served on the defence.
Am I right to understand, Commander Chew, that you were responsible for issuing the direction that the brief be served directly on defence together with the summons?
Yes, I was.
Can you talk me through what the ordinary process is for adjudication of a hearing brief?
The normal process is the case officer compiles the brief of evidence, which goes to their sergeant or team leader for a review of the evidence presented and or the evidence collected. That then goes to an adjudication position or sergeant who looks at it again from an evidentiary perspective and to ensure that all the statements and everything are there.
Can I just stop you there? And I just want to bring up a document, AFP.001.001.0706. Am I right that the adjudication process that you've just referred to is documented?
Yes, it is.
Okay. Is this the document or the form that is intended to record that adjudication process?
It appears to be, yes.
Yes. Okay. Please go on.
After the team leader makes an assessment, and you'll see in that form there's various sections of it that relate to the informant and then the sergeant. After it's adjudicated on, again, to check the sufficiency of evidence and the statements, et cetera, then it goes to judicial operations to essentially be checked for content and administrative purposes to make sure it's in line with the agreement or the protocol document between ACT, DPP and ACT Policing.
So just stop you there. Judicial operations, that is a body within ACT Police?
Yes, it is.
And you refer to it checking content. Is an aspect of that to ensure that material is not included in the brief that is either the subject of a privilege such as legal professional privilege?
That should be in disclosure statements.
So that's the fact of that is recorded in the disclosure statements.
I think so, yes.
But is your understanding that it is a function of judicial operations to ensure that such information is not actually included in the brief of evidence?
Yes.
Now, another aspect of documents that might be included in the disclosure statement is a material that's subject to statutory protection, such as counselling records.
Yes.
And am I right to understand that an aspect of the function of judicial operations within ACT Police is to identify and ensure that material matching that description is not included in the brief of evidence?
Yes.
Okay. So what happens from there?
And that document or that brief is sent across to the ACT DPP for allocation to a prosecutor, and then the prosecution commences.
And am I right to understand that there is a collaborative agreement between ACT Police and DPP?
Yes.
And an aspect of that collaborative agreement provides for a brief of evidence to be provided to the DPP within a particular period after a summons is laid?
Yes.
Is your understanding that an aspect of the function of the DPP with respect to the brief of evidence is in effect to be another check and balance regarding the content of the brief and to ensure that material that is subject to statutory protection or legal professional privilege is not included in the brief that's served on defence?
Yes.
Now, if we can go to the 3rd of August, on that day you had a meeting with Detective Superintendent Moller. Now, again, you don't have a file note of this meeting, but I want to suggest to you and give you an opportunity to comment upon what Detective Superintendent Moller records of that conversation. He records that you said that there is no need for adjudication. We have had it independently reviewed and have legal advice, so no need to have it adjudicated. Is that a correct?
Well, no need to have it adjudicated through the normal process.
And when you say adjudicated, what do you mean by that?
Well, due to the nature of the investigation and the fact that it had a lot more oversight from various levels of detective sergeant, detective inspector and detective superintendent, the adjudication on the sufficiency of the brief to go forward had been done at those stages.
So when you say sufficiency of the brief to go forward, are you talking about sufficiency of the evidence included in the brief, or are you talking about an adjudication process to ensure that only the proper content that can go to the defence is included in the brief?
The latter.
The latter. Can we just go back, though, to the direction you actually issued with respect to at least the DPP? Operator, can you please display AFP.2003.0002.8605 and turn to .8606. Would you accept, Commander Chu, that no part of your direction in relation to what was to occur, what was to be done by the ACT DPP included an adjudication of the content of the brief of evidence in terms of whether or not it included statutory protected material or material concerning legal professional privilege and the like?
Yes, I accept that.
Okay. So would you accept, albeit with the benefit of hindsight, that when you said to Detective Superintendent Moller on the 3rd of August, the brief has already been adjudicated, at least insofar as it concerned the DPP, it hadn't been adjudicated for its content?
That would be acceptable, yes.
Okay. Now, 2 days later, on the 5th of August, you have another meeting with Detective Moller. Again, you don't have a file note, but I'll put to you what Detective Superintendent Moller records of that conversation. there was a discussion in relation to service of the summons on Mr. Lehrmann. Do you recollect that?
Yes.
During the course of that discussion, Detective Superintendent Moller said to you, and this is with respect to service of the brief, I suggest, this is outside our normal procedures. Normally we go through the AP Sergeant for adjudication. I think we should still do this ?
Yes.
Yes?
I recall a conversation like that, yes.
And you said to Detective Superintendent Moller, we can't, mate. We can't, mate, no need. We have had it reviewed and I'm comfortable with that. Let's just get it served and move on.
That would be a reflection of that conversation, yes.
What was operating on your mind in terms of that statement that you just wanted the matter to move on without an adjudication in the face of Detective Superintendent Moller expressing concerns to you about that ordinary process not happening?
My concerns or my thinking at the time was that the matter had dragged on. We had the director's advice that the matter should go to court or should commence a prosecution. We had the intense media scrutiny in the environment that was occurring at the time. The brief or the brief of evidence had been compiled throughout the investigation, and the fact that we were operating in a COVID restrictive environment, which made a few normal practices quite challenging in relation to service of summons, adjudication of brief. And additionally, due to the commentary that was being held, the possibilities of fair trial for the alleged offender, with all the media commentary and the commentary surrounding it, would be challenging.
Can I just unpack that with you? You say that, I think in effect, it had been looked at by various senior investigating officers, but you accept that it hadn't been adjudicated by those officers in terms of its content.
Yes.
And you were directly informed by Detective Superintendent Moller that that was a matter of concern for him.
Yes.
In terms of the COVID environment, what was it about the COVID environment that precluded an adjudication process happening?
Well, the courts were operating on restrictive operating hours. As I said, my intention was that the amount of oversight and adjudication progressing through the investigation was sufficient to provide the brief of evidence in relation to the sufficiency of the evidence.
But how could you have been satisfied in the face of what Detective Superintendent Moller said to you, that there was a sufficient adjudication of its contents in terms of the production or material that shouldn't be included in the brief?
I accepted that during the process of, as I wasn't directly involved in the compilation and the compiling of the brief, and I would have expected that those checks and balances would have been occurring along the way.
You probably assumed that this brief had been passing through many hands, including the directors, and by that stage, surely everything that should have been taken out had been taken out.
That would be correct, yes.
You referred earlier to a concern about the matter dragging out. Was an aspect of what was playing on your mind in terms of issuing that direction adverse comment about the DPP with respect to dragging its feet to lay a charge?
No, I wouldn't say that, no.
Coming back to the question about the COVID environment, you talked about how COVID could operate in terms of the court processes, but I'm just struggling to understand how COVID would have precluded an adjudication happening either internally within the ACT Police, as Detective Superintendent Moller was urging you to do, or otherwise having that done by the DPP.
It wouldn't have precluded it, but as I said, the matter was dragging on and the commentary surrounding the matter was increasing.
So would it be fair to say that those two matters you've just mentioned, the matter dragging on and the media commentary increasing, was really what motivated you to issue the direction on that day?
Yes.
And would you accept that in hindsight, albeit that really shouldn't have occurred?
Yes, in hindsight, yes.
Yeah, and that's because a proper adjudication process hadn't taken place?
Yes.
Nothing further from me, Mr. Sock.
Thank you. Mr. Tedeschi, for various reasons, we have to adjourn at 4 today. So you can start, or you're not going to finish in 20 minutes.
I might.
All right.
I'm content to start.
All right, go ahead.
Commander, would it be fair to say that you and the other police involved in this case were under a lot of time pressure that led to your decision that there be no adjudication in this matter?
Yes.
There was pressure from the media, pressure from Ms. Higgins and her partner, and pressure from other sources as well, including pressure from the DPP.
Yes.
Do you agree that it's very unusual not to have an adjudication of a brief that goes out?
Yes, it is.
It is common?
It is unusual.
It is unusual. And is it also very unusual for the brief to be served at the same time as the summons?
Yes, it is.
Usually what happens, is it not, that police wait until they find out if there's a plea of not guilty and then they put the brief together and serve it?
Generally, yes.
That saves a lot of time, because if there's a plea of guilty, you don't have to go to the same amount of effort to prepare the brief.
That's correct.
So this case was very unusual from the point of view of the parties, that the brief was served at the same time as the summons. In order to save time, why didn't you just have the summons served as quickly as possible? Why did you decide to have the brief served as well?
Again, to start the progression of the matter, so that to expedite the potential of getting the matter before court at its first mention date, which would then allow us to seek suppression orders from the magistrate to limit, if not reduce, the external commentary that was occurring.
But you could have got that just with the summons being served without serving the brief at the same time?
In hindsight, yes.
And of course, the other thing that was very unusual was that the brief was served directly by the police on the defence rather than through the DPP.
Yes.
I think it's the agreement between the police and the DPP is that the police provide the brief to the DPP, who then serve it on the defence.
Yes, that's correct.
As you've explained to counsel assisting, that provides another level of checking.
Yes, it does.
So from the point of view of the parties, this was also very unusual, would you agree, in terms of the service of the brief directly on the defence?
Yes, it was.
Now, you subsequently found out that accidentally some counselling notes of Ms. Higgins were included with the brief?
Yes, Detective Superintendent Moller informed me of that. Yes.
That should not have happened.
Should not have happened.
And is this the only occasion that you're aware of where that's happened?
It's the only occasion that I'm aware of, yes.
All right. And we also informed that the audio of the complainant's EICI was also served with the brief, and that shouldn't have happened?
I can't recall if I was informed that the EICI had been served, but definitely the counselling notes.
Yeah. Did you find out, or do you know now, that the audio or video of Ms. Higgins's interview had been included with the brief and it shouldn't have been?
Yes, I know now.
Okay. And did you also find out that there were some redactions of personal details of police officers and witnesses and the like that hadn't been applied properly, and that they could easily be lifted so that people could see what was under the redactions?
Now I do, yes.
Right. Now, would you agree with this, that in terms of this matter resulting in the brief being served at the same time as the summons, the brief being served on the defence directly, the counselling notes being included with the brief, the audio of Ms Higgins's interview being included with the brief, and the redactions being able to be lifted, that the combination of all of those events was completely unique to this case.
Yes.
You were the one who took responsibility for saying charges should be laid,
Yes, I was.
and Superintendent Moller was the one who actually signed the summons.
Yes, he was.
Were you aware that Inspector Borman had said that he was not going to sign the summons?
I wasn't aware of that, no.
Were you aware that at a later stage during the trial, he said that if the jury convicted Mr Lehrmann that he would resign?
Well,
I'm
I
aware.
object to that. Sorry, I object to that question. It was not during the trial, it was while the jury was out.
It's during the trial.
Well,
It doesn't matter. Just put it in, put the question.
Do you agree? Did
I
you know
wasn't
that?
aware of that.
Okay. Would you agree that that's very unusual for somebody of the rank of inspector to say something like that?
Well, I can't comment on whether he said it or not. So,
Assuming he said it,
yes.
do you agree it's unusual for somebody of the rank of inspector?
Well, it would be unusual for anyone to make those sort
It
of
shows a lack of objectivity, doesn't it?
comments. I wouldn't say that, no.
Now, I'll put a link to the article below the video on YouTube, so you can click on the link, go and read the article. There's a lot more information in the article, and also there's a link there so you can read further information, watch further videos. And it's worth doing because Michael Chew was a fourth AFP officer who was involved in the Brittany Higgins-Bruce Lehrmann investigation, and he's the fourth police officer to be found corrupt or exposed as being corrupt. Now, a lot of the information in the article you're not going to read anywhere else. Same with the video. No other media is exposing this. It's blatantly obvious that Michael Chew was lying like no tomorrow on the witness stand. I think they were considering a suppression order, but then Michael Chew tried to use that as a justification for legally serving Bruce Lehrmann and his barrister the information they did, which they weren't meant to. Brittany Higgins' counselling notes, etc. They're trying to give him everything they could to undermine the prosecution, and they did that deliberately. And here's Michael Chew using suppression orders or potentially suppression orders to try and justify doing that. Well, suppression orders are a totally different issue. They don't justify handing over that material. He's trying to say, oh, they were in a rush. Well, they shouldn't have been in a rush, and he's lying all day, every day. Now, the video you just watched and the article I just published, you won't see elsewhere. Kangaroo Court of Australia's independent media. I publish a website and a YouTube channel, and I'm 100% crowdfunded from viewers like yourself. So please support my Patreon account or PayPal account. We currently have 433 supporters donating $2,373 a month on Patreon. And the link for the Patreon account will be below this video on YouTube and also on my website. And you can donate any amount, $3, $5, $10, $15, $20, $30, $40, $50 a month, whatever suits your budget. It all helps out in a big way. And please hit the like and subscribe button. And please share this video on social media. Other than that, thank you for your time and have a good day.